This is case number J1403, IA 2009. We make a correction. Case number J1403, MS 2009 00009, State of Arizona versus Stephen Anderson, who's present, represented by counsel. Happy birthday.
Thank you, Judge.
And Mr. Katz, on behalf of the state, are you present? And I don't know who you are, but you
My
can
name is Scott
introduce yourself.
Campbell. I work for Mr. Victor.
Okay.
Judge, I just wanted the court to be aware that Mr. Campbell is here and that Mr. Campbell will be assisting me throughout today's hearing, and then, if necessary, the jury trial tomorrow.
Now, any preliminary matters that we need to address prior to beginning this hearing?
I think we do have a preliminary matter. I don't know if it's a serious matter or not, but I wanted to bring it to the court's attention. Mr. Katz informed me recently, I think it was by telephone, that there's a potential issue that could be a conflict for the court. Mr. Katz communicated to me that the court has a connection with a prosecutor in the Yuma City of Yuma prosecutor's office. Mr. Anderson has an unrelated case in that office right now. So I don't know if there's a conflict. I don't know if that is true or what. So I thought I would inquire with the court to find out exactly if there is a conflict, what the nature, what the extent is, and sort of get it out, get it on the record. And so we would then know about it. And then if the court feels there's no conflict, we can then maybe take a break and discuss and see if we agree with that and then move forward or take other appropriate action if necessary.
Okay, very well. I think Mr. Katz is referring, you can correct me if I'm wrong, he's referring to the city prosecutor, Mr. Kearns, Jay Kearns, has an assistant or someone that works with him on and off basis, and that happens to be my husband. My husband is aware that I am the judge in this case. My husband has not dealt with any issues related to any case that, and I don't know, I didn't know that there was any case in city court or anything in that court, but he's not involved in any cases. He covers for Mr. Jay Kearns. He's covering actually this week because Mr. Kearns is on vacation, and they have worked together for many years. And that's the extent of the possible conflict, if you find it as a conflict. The court has no problem here in this case. The court will be fair and impartial, and I don't think that there's anything to be concerned about. And I will give you some time to talk to your client, to discuss it along with the prosecutor, if you need so.
May the state be heard, Your Honor?
You may.
Ultimately, Your Honor, the state's not taking a position one way or another on this issue. The state's prosecutor, myself, learned on or about the week of December 4th, 2009, that your husband, Mr. Greg Torok, does prosecute cases on a contractual basis for the city of Yuma. I felt that it was incumbent upon myself to inform Mr. Victor of that upon learning that. And, Your Honor, although the state is not taking a position concerning this issue, the state does want to make clear that if the defendant does decide to go forward with this case, and this case were to be resolved upon a jury verdict not in the defendant's favor, the state will be arguing that any issue on appeal concerning any appearance of impropriety has been waived by the defendant knowingly proceeding. And in doing this, Your Honor, the state will just point to a couple sources that to create a record that could potentially be reviewed so that all the parties are on the same page. There's a 1980 Arizona opinion from the Attorney General, and it looks like the citation is 1980 Arizona OP.ATTY.General 115, Attorney General Opinion Number I-80-139, July 23rd, 1980. And it looks like it's concerning the Honorable Jim Hartigan, and it's some sort of letter that's been written, what appears to be from the Arizona Attorney General, I suppose. And it is not directly on point, but it does elaborate on some of the issues that have been raised by defense counsel, and I think that perhaps this could focus the discussion. It involved a town magistrate whose husband or wife was the town chief of police here in Arizona. Now, although it's not directly on point, there were two conflicts that were identified by the Arizona Attorney General's opinion. One was a statutory conflict of interest, and I don't think that statutory conflict of interest applies to this case. The other source of the conflict of interest was brought forth by the I believe it was the former Canon 3 of the Code of Judicial Conduct. And I'm not sure if it's enacted in its current form, but this is a predecessor to what I believe is today Rule 1.2. Concerning the Code of Judicial Conduct, and I'll read in order to produce this cogently. Canon 3 of the Code is entitled, "A judge to perform the duties of his office impartially and diligently." Under A1 of adjudicated responsibilities, a judge should be unswayed by partisan interest. And the state is not alleging that, Your Honor. The state is not putting that forth whatsoever. Under Part C, disqualification, a judge should disqualify himself in a proceeding in which his impartiality might reasonably be questioned. Once again, the state is not taking a position. This is just a framework for the intellectual inquiry before the court. Among the situations in which a judge should disqualify himself are cases where he has a personal bias or prejudice concerning a party, where he knows that his spouse has a financial or any other interest that could substantially be affected by the outcome of the proceeding, or where his spouse is an officer of a party to the proceeding or has an interest that could be substantially affected by the outcome of the proceeding. And I think particularly focusing on that last provision where the spouse is an officer of a party to the proceeding or has an interest that could be substantially affected by the outcome. I think that's the key clause within this Attorney General's opinion, Your Honor. And although these cases are distinct, the case in the city court and the case before Your Honor today, the circumstances, the factual circumstances, I believe, begin on August 5th, the date at which you began to preside over these proceedings. It's alleged that at some sort of establishment in Yuma, Mr. Anderson and some of his friends or supporters engaged in certain conduct. Those are allegations. The identification of Mr. Anderson is made by a victim in the case as having had contact with Mr. Anderson previously as he discussed the facts and circumstances of this case, Your Honor. The victim in this case of the city went on to explain that Mr. Anderson has detailed to her before, and she recognized him as having a Border Patrol case pending in Yuma County, and that he was returning to court at 1 p.m. And that's how she was able to identify him. Just to frame the intellectual inquiry, Mr. Greg Torok is an agent of the state. Mr. Greg Torok is an officer of a party, the state of Arizona, Your Honor. The state of Arizona is present in the courtroom today. It's state versus Stephen Anderson in the county proceeding. I don't know how ultimately Mr. Victor will resolve this, but some of these same issues, the mere agency and the mere fact that Mr. Torok appears frequently on behalf of the state of Arizona and actually appears as covering the entire week, and I don't know if that means he has accessibility to the city prosecutor's office, resources, things like that. I don't know, and I can't speculate. The state's position is that if the defendant waives this potential conflict, this cannot be raised on appeal. It's a knowing waiver.
One thing that I think that we need to consider, and I'm sure that you're acquainted with everything that Mr. Katz read, and I'm sure he's doing it for purposes of the record, that the mere fact that Mr. Kearns, and I'm assuming that that's how your office found out of anything in related to any other case pending, is by Mr. Kearns, who is a very diligent attorney. He has been an attorney in Yuma County for many years. He's a defense lawyer, is a prosecutor for the city. That diligently called prosecutor's office, let them know, and having seen Mr. Kern's work, I have to assume that he did it because he wanted to make sure that your office was aware that Mr. Torak will not be involved, knowing that I'm the judge presiding in this case. One thing for you, Mr. Victor, because I know that you have expressed your concern in regards to delays. I know you're concerned about your client having to travel to Yuma, and in this case, it's being delayed for many reasons, and I'm sure the parties want to make sure that this case is finalized and that you do have a fair and impartial judge. One thing to consider may be the transfer of that case to the prosecutor's office, so there won't be any conflict then. There's been cases that there have been transferred, whether to the city for Mr. Kearns to take care, and Mr. Kearns have been in this court taking care of cases for the county, and the same thing can happen with that case. And I don't know the status of that case. I don't know what's the stage of it, but if it's a case where there's just allegations, still the county or the case can be transferred because of possible conflict.
And Your Honor, I'm not familiar with whether that is occurring or not, but the conflict is before the court, and Your Honor, respectfully, it is Your Honor's conflict on this case with the appearance. The possible remedy, I don't think, if that hasn't been negotiated at this time, I don't think that that's on the table before these proceedings, that it could be conflicted like that.
Well, I don't know, and you don't know.
I don't know either.
I think that one thing that Mr. Victor has to consider is all his options in the interest of his client's justice, in more than anything, his client's in the interest of justice for Mr. Anderson. In the interest of judicial economy, I think that we already extend that in a way that I never seen a case taking this long to be resolved when we're talking about a class 2 and a class 3 misdemeanor offense. But that's besides the point. The court, once again, I don't have any problem dealing with this case, hearing this case, and if I did, I will recuse myself. If I felt that I wouldn't be fair and impartial to Mr. Anderson, I will recuse myself. And one other thing that you may want to inquire about is the stage of that case. I don't know if you know, if you're acquainted, if you're representing him on that case, to know what is the extent that case have been, that Mr. Torak has been familiar with, and it's up to you at this point. I will give you as much time as you need to discuss with your client. We dedicated this day to hear this case, so it's up to you. But I do agree with the state in regards to you deciding that there's no conflict, that you're okay with this court here in this case, that you will be waiving, bringing anything up in regards to any conflict. If you're not satisfied with the rulings of the court, obviously we haven't heard anything regarding the motion. And
Mr. Victor, Your Honor, the state's not making any assurances or guarantees that there would be any conflicting of the case from the city to the county. I simply don't know the status of those discussions between the leadership of my office and the leadership of the city. So the state's not making any guarantees or assurances that Mr. Anderson's case would be moved to the county. I simply don't know.
Judge, I think more has been made of this issue than it really deserves. I've spoken with Mr. Anderson. Mr. Anderson is not asking me, nor is it my wish, to try to change judges at this point. It seems like the state has spent lots of time to establish the fundamental notion that a knowing waiver of an issue can't be raised on appeal. Of course, that's the case, Judge. We don't take issue with that. I'm not convinced we even have an issue here. That was the reason for my inquiry at the beginning, to find out what the facts are. The court has reported the facts. That court wasn't even aware of this case, doesn't know anything about it. Court doesn't have any information about anything in regards to that case. I don't see any conflict here whatsoever. So I agree with the state that, you know, if we waive the issue to the extent it's an issue at all, that it's not something we can raise on appeal. I certainly agree with that. The state is also saying that the state doesn't have any issue with this court's ability to be fair and impartial. At least that is the state's position today. That's not been the state's position in the past. But we've never had any issue with that. I'm not hearing anything, nor am I aware of anything that would cause me to think that this court can't be fair and impartial in regards to Mr. Anderson and his case and the issues before the court. So, with that said, Judge, if anything changes, if the court was to come into different information, new information, I would certainly expect that the court would raise that issue at that point, and we could deal with it at that point if it ever becomes an issue. But at this point, it doesn't sound like we have an issue. We're not asking for a change of judge, and I think we should just proceed with the issues that are on the table today.
This is the time set for a motion to suppress, and this motion was filed on September 23rd, 2009. There's been a response by the state October 5th, 2009, and an answer to that response on October 9th. The issues to address, the motion specifically wants to suppress the issue of the seizure of Mr. Anderson's body by Border Patrol agents as it was illegal seizure in violation of the Fourth Amendment of the United States, and along with that, the refusal to obey peace officers' orders to relocate his vehicle and himself, as the order was a continued illegal seizure of his body, and he was permitted to passively refuse to obey the order as a matter of law. Is the state ready to proceed?
Your Honor, the state is ready. The state is concerned about, respectfully, Your Honor's framing of the two issues with regard to this suppression motion. Your Honor, it's quite clear that Mr. Victor is challenging the constitutionality of Interstate 8 mile marker 78's checkpoint. I believe I heard referenced in the framing of these issues before the court by Your Honor that also that whether Mr. Anderson was entitled to passively refuse to comply. Does Your Honor contend or assert that those issues are before the court in this pretrial motion?
Did you read the motion?
I did, and Your Honor,
You don't read that?
I don't agree whatsoever that the issue of whether Mr. Anderson is entitled to passively refuse is in any way apropos of a pretrial motion. Your Honor, and in numerous pleadings, the parties have debated this. That is a factual defense, a potential factual defense. I'm not going to afford that defense any merit within this presentation. That's a potential factual defense that might possibly be raised at trial, whether he can passively refuse. The issue before the court on the suppression motion, Your Honor, and I believe State v. Mejak and State v. Kerr and Rule 16.6b, this court cannot consider factual defenses in a pretrial setting. This court can certainly consider whether the checkpoint was constitutional in a pretrial setting, in a suppression motion, and acquisition of evidence, and whether it complies with Martinez-Fuerte, its progeny in the Fourth Amendment. But this court, respectfully, Your Honor, cannot consider factual defenses. There is no such authorization in the law to raise factual defenses in a constructive or pseudo rule or motion for summary judgment. There is no motion for summary judgment in that regard, Your Honor. And with regard to that second prong of the inquiry, the state does disagree, that that is not the inquiry before the court today.
Mr. Victor?
I'm going to let Mr. Campbell address that issue, Judge.
Your Honor, motion to suppress for the Fourth Amendment would be to suppress the seizure of his body, and under the fruits of the poisonous tree doctrine, to suppress any fruits of that seizure. If he was illegally seized in the roadway and they directed him to go to the secondary inspection station, that would simply be an illegal seizure over there rather than an illegal seizure here. It would be a fruit of the original seizure. I believe I briefed it in the motion that the current state of Arizona law is you cannot violently resist an officer who is making an illegal arrest or, in this case, perpetuating an illegal seizure. And there's no allegations that he resisted the officers. He's not charged with resisting arrest. So the fact that he was asked to be he was told to be illegally seized over there than over here is simply fruits of the poisonous tree, and I think it's within the purview of this court to determine that in the motion to suppress.
So the issue will be whether the search, the seizure was illegal or not within the Fourth Amendment, and if the court determines that it was not, then the fruit, which is his refusal, will have to be addressed then.
Yes, Your Honor.
And, Your Honor, I would agree more with the framing of the issue in that sense, in classic terms and concepts as presented by counsel. But, Your Honor, the state will re-urge at this instance that we're about to embark on a hearing, and as professed by defense counsel at an earlier hearing, that could take all day. This hearing is amounting to, potentially, a bench trial before a jury trial, Your Honor. The state has brought forth to Your Honor's attention the cases of, I believe it was State versus Tassler and the State versus Windus. And speaking in terms of fruit of the poisonous tree, Wonsan, its progeny, Mapp versus Ohio, things like that, Your Honor, quite simply, the state at all times contends that checkpoint on Interstate 8 at mile marker 78, that checkpoint's constitutional. It's been constitutional for approximately 30 years. That's the state's contention. But for the purposes of an argument or a hypothetical in an inquiry, if Your Honor were to decide that checkpoint happened to be unconstitutional, Your Honor, under the recent Supreme Court opinion in Herring, which indicates that a defendant doesn't have a right to suppression of fruits, he has to make a policy argument of it. Number one, does it result in appreciable deterrence? So you have the whole Herring argument that the state will be bringing forth. Does he even have a remedy under Herring and the new posture of the United States Supreme Court with Justice Roberts' writing as of 2009? The state argues that he doesn't have a remedy in that sense. But even before that, Your Honor, there's the Tassler and Windus case. And the Tassler and Windus case kind of focus on the idea, and one or the other involved, for example, an unlawful entry into a subject's home.
Okay. Well, Mr. Katzen, respectfully, I'll use your favorite word. Let's deal with one issue at a time. Let's start this hearing and determine whether this seizure was not within the Fourth Amendment, and then we'll deal with the second part of this motion.
And following from that order, Your Honor, and the state will respect that. Typically, I've seen done before in suppression hearings, which particular piece of evidence would Your Honor like the state to focus on as being capable of being suppressed in this case? Mr. Anderson's person, potentially, I don't follow that argument. Defense counsel previously wrote in numerous pleadings that they were seeking the suppression of criminal charges. That's not possible, Your Honor. This court isn't authorized to do that. Defense counsel previously argued that they were arguing for the suppression of subsequent criminal conduct. If the state can be provided with, Your Honor, of how to focus its questioning and testimony at this hearing of which evidence is the subject of the inquiry, that would help both judicial economy and the presentation of the evidence.
Mr. Victor?
Your Honor,
One of you.
thank you, Your Honor. I think I'll be doing most of this.
Okay.
previous motions that Mr. Katz spoke about have been handled by the court, and they're not at issue today. So whatever was brought up in those previous issues, I think just doesn't matter today. Your Honor, an arrest is a seizure of a person. The stop at this checkpoint, the state admits, is a seizure of Mr. Anderson's person. And if it's unconstitutional, then you suppress the seizure. He was, for all intents and purposes, not there. The court doesn't consider it, just as if the court suppresses the seizure of drugs. Legally, the drugs don't exist in a court of law. And we're asking the court, if the court finds that the checkpoint as it was run on April 14th violated the Fourth Amendment, to suppress the seizure of Mr. Anderson's body because he was seized at that checkpoint.
Your Honor, if Mr. Anderson, or if any individual, let's assume that individual Jones is stopped at this same checkpoint, and let's assume that this checkpoint is determined by Your Honor to be unconstitutional. If individual Jones, while seized at that checkpoint in primary, when the agent asks for the citizenship, identification, and status, if individual Jones, not alleging that this occurred in this case, of course, if individual Jones shot the primary agent, Your Honor, would defense counsel then argue that since he shouldn't have been stopped, under the Fourth Amendment, therefore that subsequent criminal activity, the homicide of the primary agent, should be suppressed? And Your Honor, that's what the Tassler and Windus decisions deal with. This court is not authorized to suppress subsequent independent criminal activity. Mr. Anderson's person is being argued as subsequent criminal activity by the state. Mr. Anderson's criminal activity began after that seizure. This court, under Windus and Tassler, cannot suppress subsequent criminal activity. The refusal to go to secondary, the obstruction of the highway, this all occurred after an allegedly invalid seizure. Even if the seizure itself, hypothetically, is determined to be invalid, those subsequent criminal acts exist independently of that, and they are not capable of being suppressed. Just as a person could not take out a gun and shoot the primary agent, Your Honor.
Did you have an opportunity to read the cases that Mr. Katz is referring to? Because I did, and I know what he's talking about in reading the motion. That was one of the things that I was in my mind when I read these two cases that he's referring to. Did you have an opportunity to read those cases?
I have not read those cases, but using it as an example, Your Honor, if Mr. Anderson taken out a gun and shot one of the Border Patrol officers, that's a different tree. That's a separate crime. He's being charged with not getting out of the roadway and not going to secondary, each of which is a continuation of the original seizure. It is a fruit of the same tree. There's no allegation that he committed a separate crime, simply a continuing series of events that started with the first seizure.
Mr. Katz, and I read the cases that you're referring to. Let's start with this hearing. And if it comes to a point where this case is applied to this particular case, the court will consider that. But let's proceed with this hearing.
Yes, Your Honor. The state could call its first witness.
Okay, and who would that be?
Agent Ernest Gomez.
Okay. It may take a few minutes. We do have the agents in a different location.
Judge, just for purposes of the record, we want to say that we do invoke the rule at this point. So I don't know if the court wants to bring them all in, inform them about their responsibilities, not to talk to each other about the testimony, the case, those types of things, and then send them back out, or deal with it one at a time. That's the court's decision, but I just want to make it clear that anybody who's anticipated to be a state's witness for this hearing should be excluded from the testimony in the courtroom.
And
Make sure that they're all brought in.
may I raise a question of law? I have a concern. Does the rule of exclusion also apply to state's witnesses that would be testifying at the trial? because the state would argue that the presence of any witnesses that will be testifying considering the scope of this hearing should also be subject to exclusion, such as defense counsel's character witnesses.
Judge, this hearing is not the trial. This hearing is a open to the public hearing, and so if people are going to testify at this hearing, they're subject to the rule. If they're not going to testify at this hearing, then they wouldn't be subject to the rule. The trial starts tomorrow, and then the issue tomorrow will be if they're going to testify at the trial and the rule is invoked, they need to be excluded from the trial. But there is an interest here that's a sort of an open forum, American public forum type of an interest. This hearing's open to the public, and so if people aren't testifying at this hearing, it's an overly broad reading of the rule to exclude anybody who may appear at the trial from this pre-trial hearing.
The state was asking it more for the purposes of its own witnesses, Your Honor. I've noticed the Yuma County Attorney's investigator, Mr. Derek Shyrock, as a witness at the trial. Mr. Shyrock will not be testifying at the hearing today. He's here in a support and assistance capacity with the technology. So with that being the standard, Your Honor, I suppose it seems that Mr. Shyrock can be present, and the state's question's been answered.
I think so. It will, Ms. Bailiff, will we able to?
Yes.
We need them all here so they can.
Yes.
Your Honor, the state would ask if I haven't had contact with my case agent this morning, Case Agent Jones. He could possibly be with the other witnesses. The state would ask, as typically done, that Agent Jones be permitted to sit with state's counsel. And if Mr. Jones is in the special room, that be communicated to him that the state requests his presence. Your Honor, may I mark some exhibits while we wait?
You may.
I'm marking Mr. Anderson's handheld camera video from the checkpoint.
The full one coming up?
Yeah.
Right, the hour-long one you're talking about?
It should be. It should be.
Okay.
The one he's holding and talking.
I got you.
And then also the overhead shot of Agent Springmore indicating secondary and running the dog.
Do you have any exhibits that you would like to be marked?
I have none to mark today. I do.
Your Honor, you will like
I need all the agents.
Hey, Lou.
Just go ahead and have a seat. Use the jury box. And when I have all of the other agents, I'm going to place you all under oath. It may take a while, so I don't want you to be standing there.
This is an account of what occurred. Whole thing. We're here today. Why not? Well, you can waive those defenses if you're making the factual defenses and stay with the Fourth Amendment inquiry, and then you don't have to close the whole thing. If you're making factual defenses, that he's entitled to lawfully resist at this hearing today. If she's
Let's
making
just say he did.
It's in more than one state.
It's my goal to play the relevant segments, not the segments in which Mr. Anderson is driving up the checkpoints. Only the segments from that day.
Yeah, I would object to the other ones.
I'm hopeful. We have a table of contents. Your Honor, may the state call first witness?
I'm waiting for all the other agents to place them under oath.
Oh, I'm sorry.
We'll make the objection while you. Waste of time. Or it's fourth reason.
Okay. Please raise your right hand. You swear or affirm that the testimony you're about to give to this court is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Okay. Now, officers, agents, the exclusion of witnesses rule has been invoked. And what you're required to do is, you're not going to be in the courtroom, you are ordered not to discuss your testimony among yourselves, to talk about this case among yourselves. You will be called one at a time to testify. Which is the agent that you want sitting at your table, Mr. Katz?
Your Honor, for the purposes of this hearing, Mr. Jones has the option if he wishes to sit at the table, although if he prefers to sit in the secured room, it's up to him.
And who's Mr. Jones?
Officer Jones, I apologize.
You may stay here. Okay. And the rest of you will be escorted. Who's your first witness, Mr. Katz?
Agent Gomez.
Okay, Agent Gomez will remain in the courtroom, and the rest.
Your Honor, may I retract that? I'd like to call Agent Sims. I apologize. Agent Sims.
Okay, Agent Simpson, you'll remain in the courtroom. The rest of you will be escorted to the private room.
you first.
You can take the witness stand. Make sure the microphone is close enough to you so we can hear you properly.
Judge, I have an objection before we get started. I want to get out of the way.
Okay.
Mr. Katz, from what I understand, is intending to play an hour-long video of what occurred at the scene, which may or may not be important if we get to a jury trial, just to show the jury the scene. However, for today, I think this would be a horrendous waste of time because the agents are here. The agents can testify to exactly what happened, and I don't believe there's going to be anything in those videos other than just sort of seeing the scene, which might be relevant to things at the jury trial, but is not relevant to the strictly legal issues that the court's dealing with today. And so under 403, I would move to not do that today because I think, and to use the language of 403, it's just simply a waste of time. Unless the court would find, or the court feels there's something in that hour-long video that would assist the court in some way beyond the live testimony and independent recollections of the officers who were there, which I can't possibly think of what would assist the court at that point. I just think it's a huge waste of time to play an hour-long video to just establish what the officers are going to establish by testifying.
Mr. Katz.
Your Honor, as a procedural formality, I've seen this done many times, and I say this respectfully to counsel at the defense table. For the purposes of this hearing, counsel needs to select one representative who will be speaking for the defendant, Your Honor. That is typical of these hearings. Additionally, Your Honor, what better evidence than the crime which was captured by Mr. Anderson himself? Defense counsel, either Mr. Victor or co-counsel, routinely have been raising factual defenses in this pretrial setting, Your Honor. The state thinks that's improper. What better way to recount the event for Your Honor, the fact finder at this hearing, than for Your Honor to see the video? Your Honor, additionally, this is a video that will be admitted into evidence at the trial, where the state will be has the intention to admit at trial, and perhaps that could serve the dualistic role of reviewing the tape for the trial itself. But it's highly probative, beginning from the very first moment when Agent Gomez encounters Mr. Anderson and he's videotaping him, and that's where the crime begins, Your Honor. Typically, from what I understand, people, when they're allegedly committing their criminal activities, don't give the benefit of the court of videotaping it themselves. Your Honor will have a first-hand account of the alleged Fourth Amendment violation that's being proffered by defense counsel. Your Honor, it's highly probative. It's not a waste of time. And it speaks to the fact that it's not a waste of time since Mr. Anderson himself decided to videotape his crimes as they were occurring. He found it probative, Your Honor, and the state finds it probative as well.
The objection is overruled. I'm interested in seeing that video.
Judge, just to respond to the other issue in terms of who's going to speak, I've had the privilege of trying several cases with other attorneys, and I've never once been restricted to just sort of one lawyer for the entire proceeding. The restrictions that to my recollection, that I have always had are per witness. In other words, one attorney will handle one witness, or will be assigned a particular witness, and then if they choose to have a different attorney to handle a different witness, that's fine. So we don't intend to have both of us asking questions of the same witnesses. We intend to have one attorney, which could be me, could be Mr. Campbell, for each witness. That's how we would intend to proceed. I don't think anything's inappropriate about that.
I'm
Your Honor,
not concerned about that. I think Mr. Katz addressed it in a way that I wasn't sure if he wanted me to request that you assign one attorney to be the one speaking all the time, or I don't have a problem at all.
and Your Honor, does that also apply to one attorney making opening and closing remarks concerning the constitutionality of the search, or will Mr. Victor be able to give his opinion on the constitutionality at the close of these proceedings as well as co-counsel?
I think that they're going to make a decision between the two of them who's going to address the court and when. I'm not sure what your concern is.
My concern is that the waste of time, which is being proffered by defense counsel and originally playing this video, if we're going to have numerous comment on the same legal issue in closing from both defense attorneys, Your Honor, I mean, the state has potentially 13 prosecutors who are well aware of Martinez Fuerte, who can all give their opinion and an educated opinion on that since Martinez Fuerte was decided, I believe, in the late 70s. It's a case that's well known. I'm just trying to focus the inquiry and that one
Mr.
attorney.
Katz, trust me, I'm interested in making sure that this case moves along as quick as possible in the interest of justice. Once again, I mentioned before, the interest of time, in my opinion, is borderline violated at this point. So we got this whole day for this hearing. I'm giving people an opportunity to have their time to address the issues, and I have full confidence in the two attorneys sitting in the defense counsel table, like I have full confidence in you that you're not going to waste this court's time any longer.
And Your Honor, I drank Officer Jones's water. I apologize.
Well, that is a violation of this courtroom. You
What can I say?
Bring your own water. We'll bring you more water. And feel free, the rest of you. This courtroom can get really hot, especially when we have a lot of people. If you need more water, please. If you need any break, let me know. You ready to proceed, Mr. Katz?
I am, Your Honor. Agent Sims, can you state and spell your name for the record, please?
My name is Mark Sims, M-A-R-K-S-I-M-S.
And who do you work for currently?
I work for the United States Border Patrol.
In what capacity are you a Border Patrol agent?
I'm a supervisory canine instructor.
And who do you supervise with regard to the canine agents? Who are you responsible for?
The canine handlers and their canines
Which region of canine handlers?
in the Yuma sector, including all 3 stations within the Yuma sector.
And the Yuma sector includes which stations?
Welton Station, the Yuma Station, and the Blythe Station.
At mile marker 78, is that considered the Welton station?
It is, yes,
And
sir.
you're responsible for that?
Yes, sir.
Can you briefly describe how you became a supervisor?
I was in the Border Patrol for, I've been in the Border Patrol for 13 years. I became a canine handler 7 years ago. I became a canine instructor shortly after that. So I've been an instructor for a little over 6 years in the canine program. And I eventually became a supervisory position came open, and I applied and I got the position.
Do you teach new canine handlers the procedures that are used at mile marker 78?
Yes, I do.
Typically, do canine handlers go to a training session before they encounter your training?
Right, before they arrive at the sector, they do 6 weeks of canine training in El Paso, the Canine Center in El Paso.
When they arrive at your sector, do you assign them to particular stations?
They're already assigned to stations by the time they get to me, but that's how they come, yes, sir.
What are the canines trained to detect at mile marker 78?
Concealed people and the odors of narcotics.
And is that every canine?
That's every canine in the Border Patrol, yes, sir.
At mile marker 78, excuse me. Now,
Every detection canine. The Border Patrol has different canines for different operations, but at the checkpoint, that's their job.
do you supervise Gary Spoonamore?
I do.
Do you supervise Agent Griffiths?
I do.
And how do they work? What are they employed as?
They're employed as canine handlers at the checkpoint for the Welton Station. They're trained to find and look for terrorists and weapons of mass destruction, undocumented aliens and narcotics trying to infiltrate into the U.S. there at the checkpoint at Welton.
Is the primary purpose of those canine agents to find narcotics?
Primary purpose is to prevent terrorists and weapons of mass destruction and then aliens and then narcotics as well.
Can you kind of briefly explain how you supervise Agent Spoonamore, for example, what your day-to-day supervision entails?
Day-to-day, I'm not the real day-to-day supervisor. I help him with his canine training, and I help him with any issues that he has with the canine, health-related and training issues.
Do you provide continued canine training to Agent Spoonamore?
Right. The canines receive maintenance training, which is every 2 weeks. They get 8 hours of training on the odors in which they're trained to detect, and then I help them with any issues that they have at the checkpoint.
Are you familiar with terms such as pre-primary and primary inspection as it
Yes.
relates to mile marker 78?
Yes, sir.
What do you have your K-9 agents do in pre-primary?
In the pre-primary portion of the checkpoint, they conduct canine sniffs of vehicles as they approach the primary position of the checkpoint. So they will encounter the vehicle before the vehicle actually reaches the primary position.
And how do they encounter the vehicle? What have you trained them to do?
They work the dog along the side of the vehicle to sniff the air coming around the outside of the vehicle as it passes through the pre-primary position before it arrives at the primary position.
And can you kind of explain where pre-primary is in relation to primary?
Primary is where the vehicle comes to a stop, and then the agent that is in the primary position asks the questions, immigration questions, and it actually has contact with the individual driving the vehicle. Pre-primary is anything before that.
How many pre-primaries are there at mile marker 78?
There are 2 lanes, so there could be 2 different pre-primaries, but there's only pre-primary is the position prior to primaries.
Okay. So pre-primary occurs in lane 1 and pre-primary occurs in lane 2?
Yes.
And do K-9 agents go back and forth?
Yes, sir, they do.
And what is contingent upon how the agents go back and forth between those areas?
Depending on the traffic, if sometimes they'll have completed a canine sniff of a vehicle in the one lane, and then the traffic will arrive in the other lane, and so they'll go to that lane. Or if there's only traffic in the other lane, then they'll go to that lane, but kind of traffic dictates.
So you've trained your K-9 agents to constantly be moving in pre-primary?
Yeah, and in order to maximize the amount of time and the amount of people that we can get through there, we try to get them to work between both lanes.
Are you familiar with the phrase K-9 alert?
I am.
What does that mean?
Alert is a change of body posture and increased respiration when the dog first encounters the odors he's been trained to detect. That means that you get that physical change when the dog finds what it is that he's looking for.
Is the primary agent capable of knowing when the K-9 alerts?
The primary agent he's certified to see that. That's what every year there's a certification, and the primary, not the primary agent, but the canine handler,
Yes.
is the one that is.
My question is, if an agent is working primary, is he trained to know when the dog alerts?
No, he's not.
If he's not trained to know when the dog alerts, how does he know that the K-9's alerted?
The canine handler informs the primary agent that the canine is alerted.
And how have you trained some of your agents to inform the primary agent that the K-9's alerted?
They'll put up 2 fingers or tell them to put it in secondary. Usually they'll just tell them to please place that vehicle into secondary, or they'll hold up a 2, which means secondary. It's a hand signal. It kind of differentiates between the handlers and the people that are working there, but generally it is put that vehicle in secondary or hold up a 2.
Let the record reflect Agent Sims has held up 2 fingers to indicate. Now, after a dog's alerted, what have you trained your K-9 assistants to do then, or K-9 agents?
After the canine is alerted and the canine handler has informed the primary agent to place the vehicle in the secondary, the vehicle then goes from primary to secondary. Once in secondary, the canine handler asks the individual in the vehicle for consent to conduct a canine sniff in the secondary position where it's more secure, and then to ask the people to get out of the vehicle. The people generally get out of the vehicle and then go to a secure area and then conduct a second canine sniff on the vehicle, and then we'll get consent to search, or depending on kind of what happens, we'll release the vehicle right away if you don't have a canine alert again in secondary once you've removed the people, or we'll continue to search or gather more evidence to figure out what's happened there, what's going on in that position.
Are you familiar with some of the duties and responsibilities of primary agents?
The primary agents, yes, sir.
What are some of the reasons that primary agents can refer vehicles to secondary?
If the person that's driving the vehicle is acting suspiciously, or if he smells something, if he smells marijuana, or just sees something that's out of order, or something that gives him any type of suspicion that there's something going on or amiss in this vehicle, immigration related, drug related, or anything, that person can then place the vehicle on the secondary.
Typically, what's the first question or type of question that's asked by a primary agent?
Maybe please state your citizenship, or to have them give their citizenship or what country they are a citizen of.
If you know, are primary agents trained to ask about narcotics initially?
No, they're not trained. They're not trained to ask about narcotics right away. No.
It's their training, from your knowledge, that they ask initially about citizenship.
Yes, sir.
After a vehicle is referred to secondary on a dog alert, do primary agents assist at that point?
Yes, sir, they do. They'll help. They'll help with maintaining security of the people that are in the vehicle because you're having everybody get out, and so they'll help with that. And then the canine handler will do pretty much the rest.
Are you familiar with Agent Spoonamore's work performance?
I am.
Briefly, can you describe his work performance for the court?
He's a good worker. He's very good at what he does.
Is he competent at canine handling?
He is.
Have you viewed Agent Spoonamore work lately?
I have.
Do you know the name of Agent Spoonamore's canine assistant?
His
Dog.
his dog Jerry.
Okay. And how long has Agent Spoonamore been with Jerry?
2 years, I think. I don't know I don't know the exact amount of time.
And is Jerry certified by United States Border Patrol?
Yes, he is.
Has Jerry ever been removed from service, to your knowledge?
Not to my knowledge.
Are you familiar with the events of this case?
Yes, roughly.
Was Agent Spoonamore working on that particular night of April 14th?
Yes, he was.
Okay. Was he working with Jerry?
He was.
Have you spoken with Agent Spoonamore about this case?
Not too much.
Your Honor may have a moment. Is the checkpoint at mile marker 78 in the jurisdiction of this court?
Yes, it is.
Do you know why the checkpoint was placed at mile marker 78?
That's an operational thing at the station level. I couldn't tell you exactly what their reasoning was for putting it there, but at the station level, it's an operational decision.
Okay. Your Honor, I have no further questions for this witness.
Thank you, Judge. Judge, could I use the podium?
You may.
I don't know if this one moves or not.
I guess you'll find out.
Yes.
I think that it does,
If
you
I
want to.
break something, I'm sure Mr. Katz will be happy to fix it or pay for the.
I don't think that will be the case. I
No?
won't be happy, though.
All right. Thank you,
Like,
Judge.
that should be the main concern.
I'll do my best to keep you happy, Judge.
I'm not paying.
And Mr. Victor, I appreciate, I think for purposes of the record, that is the best approach, the podium.
Oh, thank you, Judge. Morning, Agent Sims.
Good morning, sir.
Agent Sims, you testified that mile marker 78 is within the jurisdiction of this court. Is that correct?
Yes, sir.
What is the jurisdiction of this court?
Yuma County?
Okay. And so this is, all of Yuma County is within the jurisdiction of this court?
I'm not entirely positive about this specific court, but I'm assuming that as county court, the entire county would be within that court's jurisdiction, yes, sir.
Okay, so do you know if we are in the jurisdiction of Yuma or if we're in the jurisdiction of Welton in terms of this courtroom right here that you're in?
This court, I'm not sure. Can you rephrase the question?
Are we in the Yuma Justice Court? Are we in the Welton Justice Court? Do you know which Justice Court we're in right here?
We're in Yuma Justice Court.
Okay. And so your testimony is that mile marker 78 is within the jurisdiction of the Yuma Justice Court. Is that right?
There's a Welton Justice Court. It should be in that. It should be in the Welton Justice Court's jurisdiction, but it got transferred to this court. So I assumed that this court would then have jurisdiction.
Okay. Would it be accurate to say you're not really sure what the jurisdiction is for mile marker 78?
Mile marker 78 is within the Welton's jurisdiction, but this court has taken over this case, so it is within this jurisdiction.
All right. Officer Sims, were you working out at the checkpoint on April 14th of this year?
No, sir.
So, to the extent you know anything about what happened out there, and when I say out there, I mean when Mr. Anderson or Pastor Anderson was coming through the checkpoint, to the extent you know anything about what happened, none of that is your personal knowledge. Is that right?
That is correct.
So everything you know, you were told to by other agents who were there on the scene. Is that right?
For this specific incident, yes,